Hello, everyone. Jax West from Stephen Avery Project and Justice with Jax and MAM Gossip on Facebook. We also have Justice with Jax on YouTube, but I decided to just make it easy today and try and do a live here on Facebook. Haven't done a live on Facebook in a while, and my computer's shut off on me randomly. But here we go, trying on Facebook. I figured I would just do Facebook instead of going on my Justice with Jax YouTube because we have a bigger audience here. Sorry, once upon a time, I used to get this stuff and right away and come live with you right away, but I'm working now and I don't have as much free time. And as it is, I've got 2 hours right now before I have to go to the next thing. Who cares? Get to the point. Well, thank you very much, Michael. I have a microphone and you don't. You will listen to every word I have to say. So, it's posted here on Stephen Avery Project. We posted it. I don't know if I posted it yesterday or today, where you can read for yourself Judge Flowers' latest denial for Stephen. I will here. Let's see. Can I post the link in here? So if you want to go read it for yourself, there it is. And it is 31 pages long. I am going to read this. I skip over some things that aren't as important or whatever, just trying to get into the guts of what Judge Flowers is saying. But before I even get into it, for those of you like Michael who just wants me to get right to the point, Stephen was denied. And we knew that was going to happen because Judge Flowers, it's the original judge, and she always denies. So we knew this was happening. No, he is not out of appeals. You always have to do this where you have to start at the original court, and then you have to get that denial before you can go to the court above it. But I am not the person I'm not a lawyer. Don't pretend to be a lawyer. So we will wait for Kathleen Zellner. I'm sure she'll have something out in the next few days to say something, and I don't know if she gets to respond to this or not. All right, but we're just going to go over Judge Flowers' denial. While I'm reading this, I will not be seeing all of your comments. So if you ask me a question, I'm not necessarily going to see it and be able to answer you. So I am not, yes, it was Judge Suckowitz. So I am not ignoring you or just not answering people. I'm reading this. So I'm not concentrating over here. And then also, before I start reading it, let me just say, while there's plenty of Facebook pages out there that you can be a guilter, on Stephen Avery Project, we believe in his innocence. So if you're just coming here to troll and post guilter things, even though I am busy right now and might not catch it, eventually we're just going to delete your comment. And that will be that. So putting that out there before I begin. All right. So, and those of you, there's lots of people who have been around this case a long time. So if anybody here asks a question while I'm reading and don't see it, please feel free to answer people's questions. This was issued yesterday by Judge Suckowitz, which is called Judge Flowers. Oh, great, Lisa. All right. Memorandum, decision, and order. The defendant is back before the circuit court with a post-conviction motion pursuant to Wisconsin statute. Through his attorneys, Kathleen T. Zellner and Associates, PC, The defendant asserts the newly discovered witness statements will establish that there is a viable third-party suspect for this offense. The defendant asserts that evidence regarding this third-party suspect was never presented at the time of trial, and the failure of the presentation of the alternative suspect undermines the confidence in the jury verdict. The defendant further asserts that the state violated the provisions of Brady. If the court rules that the third-party suspect evidence does not meet the requirements to grant relief pursuant to his request for post-conviction relief, the defendant asks that, alternatively, that the court grant him a new trial in the interest of justice, pursuant to another Wisconsin statute. Facts. Something coming from Judge Flowers stating facts. Kind of whatever, but the court will not recount the full record in this voluminous case. The facts have been set forth in numerous filings in prior court proceedings. This court will refer only to the facts alleged in the current motion before the court. Prior to the commencement of his trial in 2006, the trial court entered an order requiring the defense to identify any individuals, quote, other than Brendan Dassey, unquote, and it intended to suggest was a third party responsible for any of crimes charged against the defendant. Furthermore, the court stated that the admissibility of evidence regarding a potential third-party suspect would be required to meet all the standards set forth in the ruling in Denny. Hey, Bryce. The defendant provided notice that he would assert that there was a reasonable possibility that others committed the murder with which he was charged, including Scott Taddock, Andre Martinez, Robert Fabian, Charles and Earl Avery, and the Dassey brothers. In addition, the defendant argued that the ruling in Denny did not apply to his trial and that, if it did, he should be permitted to present evidence regarding several alternative suspects. The trial court found that the standards set forth in Denny did apply to the defendant's evidentiary offering and noted that in the absence of motive, it could be more difficult to offer evidence that would be relevant and material to a third person having committed the crime. The court concluded that nothing in the defendant's offer went beyond the level of speculation. The court stated that while the defendant identified many people with the opportunity to commit the murder, no clear motive for the crime was identified for any of the alternative suspects, failing to meet the Denny standards. After the defendant was convicted of this murder, he filed a post-conviction motion pursuant to Wisconsin statute blah blah. When I say blah blah, it's because it's got all this gobbledygook numbers for whatever the statute is. I don't care, you don't care. If you do care, go read it and pull up the statute number. The court concluded that while the defendant may have supplied evidence as to motive to frame the defendant, none of the evidence identified a motive for Bobby Dassey to murder Teresa Halbach. Without establishing any evidence of motive, the court concluded that Mr. Dassey was precluded from being named a potential suspect under Denny. The Wisconsin Supreme Court allowed the decision to stand. So, let me just say here, Kathleen Zellner is still with his case, but she's doing this pro bono. She is not paid. The Denny bullshit annoys me so much. Why can Stephen be convicted with known motive and you can't show that there are other suspects, other people that should be considered without having an ironclad motive? And it's going to go into what Stephen says is Bobby's motive in here, so I'm not going to get too into the weeds right now on it, but this pisses me off so much because there is more that would lean towards Bobby having a motive than Stephen. There's nothing in Stephen's past that says he's going to rape and murder a woman. Let me continue in reading this. We're only on page 3 of 31 so far, if you're following along. Several other post-conviction motions were filed, denied, and upheld by the appellate courts. The Court of Appeals ruled on the defendant's last post-conviction motion on July 28, 2021, upholding the circuit court's decision. The court found that the content of the defendant's motion was insufficient to entitle him to a hearing on his claims. While the motion was pending before the Court of Appeals, the defendant requested that the court stay its decision and remand the matter back to the circuit court for evaluation of a new claim. And the whole stay thing, and let me try and explain it, even though maybe I don't even understand it completely. It's like you're putting a pause on it. Something's been filed. He can only get back into court with new evidence. So you've already filed, and now you discover something new. Well, you can't just put that something new in there, because the only thing that filing can discuss is what's in that filing. So now you're putting a pause on it, and you want to go back and start at the beginning so you can add in this new stuff, so these new witnesses and such that come forward. Okay. The Court of Appeals noted that the defendant was asserting a Brady violation involving the affidavit of a new witness, Thomas Sawinski. In his affidavit, Mr. Sawinski asserted that he saw Bobby Dassey in possession of the victim's vehicle several days after the murder. Mr. Sawinski stated that he called the Manitowoc Sheriff's Department later that day, not after Making Murderer came out. Heck, right when this crime happened, he's calling Manitowoc Sheriff's Department. He called the Manitowoc Sheriff's Department later that day to report what he saw and was dismissed by the deputy. Blah, let me speak here. In its decision of July 2021, the Court of Appeals stated that the defendant's newest claims regarding a Brady violation had little or no relation to the claims before the court in that appeal. The court stated that this issue should be resolved in a separate post-conviction before the circuit court. The court further stated that, as discussed below, we are not addressing Avery's most recent filing to this court, which seeks to directly connect Dassey to Halbach's murder. If Avery wishes to raise that claim, he will need to bring a new Wisconsin statute motion. That motion would need to survive both Escalona-Naranjo scrutiny and to be found to have merit, in which case the evidence presented might supply the missing direct connection. In that event, the Veli CD evidence might become relevant to showing Dassey's motive and might bear on whether Dassey is or should have been a viable Denny suspect. We express no opinion on the merit of any such motion, as all such issues would be for the circuit court to decide in the first instance. So that Escalona-Naranjo is another case. And it's another thing that I don't understand about our system here in the States, that everything has to have happened before. So you have to find another case that something similar to your case happened. I don't get it, and I don't like it. As a result of this ruling, the defendant brought this post-conviction motion pursuant to the Wisconsin statute. The defendant asserts that by failing to disclose the statement of Mr. Sawinski to the defendant, the state withheld exculpatory evidence from the defense in violation of the Brady rule. Yeah, duh, that's clear as day. Furthermore, the defendant states that the evidence supplied by Mr. Sawinski creates a direct link between Bobby Dassey and the murder of the victim. As such, the defendant asserts that he was denied the opportunity to present evidence of a viable third-party suspect at his trial. By denying the defendant the opportunity to present that defense at his criminal trial, he argues that the issues in the case were not fully tried and that had the jury been presented with this testimony, the verdict in the case would likely have been different. The defendant is now asking the court to review the aforementioned claims and grant the defendant relief, or in the alternative, grant him a new trial in the interest of justice. I think it's pretty obvious that this guy, seeing Bobby Dassey and another guy pushing Teresa Halbach's vehicle to the salvage yard, is important evidence. And that this guy coming forward back when the alleged crime happened, not somebody who's coming out of the woodwork when making a murderer becomes popular, not somebody who's, just trying to get some kind of fame or make money off of it. The guy reported this right away. Now, whether or not this would make a difference in the jury, I don't know, because they set up that jury because there were members on that jury that were affiliated with the Manitowoc County Sheriff's Department that we know was completely corrupt. And they were constantly, Kratz, I think Kratz likes a good taint, they're tainting the jury constantly, because they'll be ordered that you can't watch anything or don't read anything, but if a jury's not sequestered the entire time, they're seeing the things that Sweaty Sweat Kratz is putting out there. And even when they were sequestered, people affiliated with Manitowoc County Sheriff's Department was putting people in there to hang out with the jury. So I don't know if a jury would have ruled differently because of the fix being in. So, but Stephen did not get a fair trial, period. And there's so much evidence that shows that this dude is innocent. All right, we are on page 5 of 31. Analysis. For the affidavit of Mr. Sawinski to be admitted as evidence, establishing Bobby Dassey, who is the killer, as a valid third-party suspect in the murder of Ms. Halbach, the defendant must satisfy 2 separate tests. The test in Denny requires the defendant show that the third party had a legitimate tendency to commit the crime at issue. To meet this burden, the defendant must show that the third party had a motive to commit the crime, the opportunity to commit the crime, and that there is some direct evidence linking that party to the crime that is not remote in time, place, or circumstances. All right, so for Bobby, that's check, check, check. I knew you'd like that, Bryce. The defendant also raises and correctly identifies that the test set forth in State versus Edmonds also applies to the admissibility, is that how you pronounce that? Of the affidavit itself. The Edmonds court established a 4-part test to determine if evidence is newly discovered and admissible for consideration by the court. First, the evidence must have been discovered after the defendant's conviction. Check. Second, the defendant must establish that he was not negligent in seeking out the evidence in question. Check, check. Third, the defendant must establish that the evidence is material to an issue in the case. Check, check, check. Fourth and finally, the defendant must prove that the evidence offered is not merely cumulative to that already in the court record. Yahtzee. The defendant further notes that only if these 4 requirements are met is the circuit court required to determine whether a reasonable probability exists that a different result would be reached in a new trial. In his affidavit, Mr. Sawinski states that in the early morning of November 5, 2005, now remember, Teresa Halbach has not been seen since October 31, 2005. So 5 days later, he was delivering newspapers to the Avery salvage yard in the course of his employment. Prior to actually delivering the newspapers, Mr. Sawinski states that he encountered Bobby Dassey and an older, unidentified man pushing a dark blue RAV4 down Avery Road toward the junkyard. Mr. Sawinski states that the car did not have its lights on. After delivering the newspapers to the Avery mailboxes, Mr. Sawinski states that he drove back towards the exit where Bobby and the older gentleman and the car still were. Mr. Sawinski states that Bobby then stepped in front of his vehicle in an attempt to stop him from leaving the property. He further states that his headlights were shining directly on Mr. Dassey at this point. Mr. Sawinski then states that he came within 5 feet of Bobby Dassey, who looked unhappy to see him on the road and was forced to swerve into a ditch to avoid him. Fearing for his safety, Mr. Sawinski called out, quote, "Paperboy, gotta go," unquote, and drove toward the exit. After learning that Ms. Halbach's car was found on the property, Mr. Sawinski states that he realized the importance of what he had seen and immediately contacted the Manitowoc County Sheriff's Department to report the encounter. Mr. Sawinski then states that after viewing the television show Making a Murderer, well, it says in here, Making of a Murderer. Judge Flowers, you've got that title wrong. He contacted the Innocence Project in New York to report the incident again. Finally, in 2020, Mr. Sawinski contacted the defendant's current counsel and the current affidavit was drafted. All right, let me pause on there before I go on to the next page. For those that don't know me, I have been following this case since Making a Murderer came out in December of 2016. I took over Steven Avery Project in 2017. I don't remember the month. Not that it matters. Somebody else started Steven Avery Project, and then they left the page because they were harassed and bullied so much by Steven Avery's family. And there's so many people who follow this case. This case has tons of fans who, like me, when you first come across this case, you're going to feel sympathy or empathy towards the family if you only watch Making a Murderer. It's not until you really dig into this case that you see what the Avery family has done to put and keep Steven and Brendan in prison. So I am one of the few out there who will say very bluntly that I do not support the Avery family. When this first came out about Mr. Sawinski, one of the Avery family, one of Steven's nieces, Chuck Avery's daughter, because the family likes to instantly defend Bobby at all costs. They are fine with Steven and Brendan sitting there. But Bobby, don't you dare say anything that's going to point the finger at Bobby, and they will come after you hardcore. I'm not going to get into what they've done to come after me. If you want to know, go buy my book on Amazon called Advocating for a Murderer, right? What is it called? Where's my book? They're all downstairs. But buy my book. There you go. And you can find out everything that the Avery family has done to me. So when this came out, Carla was trying to say that Sawinski is wrong on everything and saying that there is no ditch. There is a ditch on either side of the road. I have been to the salvage yard I don't know how many times. Let me get this thing right now. seeing this on Making a Murderer? So, I have been where the mailboxes are. All right? That's where that sign had been, where the mailboxes were. I did not steal this sign. This sign, it's a crappy hand-painted sign that Chuck Avery had done. And my husband owns a print shop and made them a real sign. And so I traded them the real sign to give them a good, decent sign. And then I took that one that sits here. So I've driven on that road, and there are, now it's not this huge ditch like it's gonna hold a whole lot of water or anything, but there is, it's a road. So the guy having to drive around them went off the road a little bit, and you call that a ditch, whatever. But it makes perfect sense, everything he's saying, on how he encountered somebody pushing it, okay? So when he is driving on Avery Lane, when he first goes off the highway, so he's driving this way, that road also would go right down into what they call the pit, the salvage yard where all the cars are parked. So when you get up where the buildings start, it will either go straight towards the pit, or you can go right where is then the salvage yard office, and then is Dolores's trailer, and then was a garage, and then you go down the road a ways, and then you would go to what was then Barb's trailer, and then Steven's trailer. Once you turn right, the mailboxes are here on the right where there's also then the road that goes to where you would park at the salvage office, or on this side to Dolores's trailer. So the paper guy is driving straight this way, and as he's driving straight this way, and now I can't remember, it was early in the morning, you know, it's dark out, and so he's driving this way, and then he's encountering somebody pushing the RAV4, also going towards the salvage yard. Okay? And that road isn't that wide. And so these cars now getting behind it, he has to go around the RAV4, where the person on the driver's side, on this side, the doors are open of the car, and the two people are pushing, one on the passenger side, one on the driver's side, door open, no lights. So as he's going around the car here with the door open, his lights are going on that guy. The other guy that's on the passenger side that he's just calling an older guy, he can't really see because he's on the other side of a car and there's no lights on and it's dark. So now he has to drive around them and then turn right to the mailboxes, drop it off, the mail. And then what I'm assuming he did, because I believe this is also what the bus would do, is, okay, so you've gone straight and then you turn right, mailboxes are there. Then there's also that road that goes to the office and to Dolores's trailer. You would then, so you go this way, you turn right, and then you would turn left into there, because that road continues and goes back to that road that goes right back to Highway 147. So the guy drops it off, turns around, comes back. So now as he's going this way, the car is still being pushed that way. So now the driver's side is closer to who's ever on the driver's side with the door open, pushing that RAV4, and your lights are on them. He can clearly see who that driver is. And so he says that Bobby tried to intimidate him. and, kind of stepped more to the middle. So that's why he had to, going this way, had to pull over what he said is the ditch to get around it. Paperboy, gotta go. Because something not right is going on there. Want no part of it. And once he sees things on the news and sees because they put out that missing poster with the RAV4 on it, and so once he saw that, he knew that was that car. Blue, green, whatever it is, I don't care. I don't believe there's multiple cars. It's depending on how the light hits that color car. It could look blue, it could look green. I'm sure at that time too, that wasn't a common color. It's something that would stand out and you would remember it. That's my opinion on it. And the guy reported it right away. Right away. He's not somebody coming forward now. He came out then, and Manitowoc covered it. Much like they covered when somebody told them that they had the wrong person for the Penny Bernstein case. Big shock. They do it again. And Stephen's attorney, Strang and Buting at the time, asked for everything. I call bullshit on you're not doing your due diligence to get everything. The state should have to give you everything. You shouldn't have to ask. And how do you know what they have and what to get if you're hiding phone calls and hiding phone records and all that? Infuriates me. All right, let's go back to reading this. We are only on page 6 of 31. Sorry, I start to rant. What time is it? Okay, I got plenty of time still. Okay. No, we're on page 7 of 31. For some reason, I was scrolled up. All right. With respect to the first requirement of the Edmonds test, the defendant states that Mr. Sawinski did not come forward and contact the defendant's counsel until April 2021. In his corrected affidavit, Mr. Sawinski states that he originally believed that he contacted the defendant's counsel in 2016. However, it was later discovered that Mr. Sawinski actually sent his communication to the Innocence Project in New York. Counsel states that this information was not relayed to the current defense team at that time. The defendant asserts that in spite of numerous discovery requests filed by his original trial counsel, the record of the call that Mr. Sawinski made to the Manitowoc Sheriff's Department was not turned over to them until after Mr. Sawinski came forward in 2021 and an additional specific discovery request was made. There's a footnote. Footnote says, the state's objections to this evidence goes to the defendant's argument asserting a Brady violation occurred. Let me turn the sound off my phone. Holy cow, people texting me like crazy. Occurred earlier in the prosecution of this case. The state's argument will be addressed in that analysis. All right, back to where... For the purposes of this test only, the court will conclude that the evidence in the Sawinski affidavit was discovered by the counsel after the defendant's conviction, satisfying the first requirement of the Edmonds test. The defendant next addresses the second standard of the Edmonds test. The defense asserts that it was not negligent in seeking out the evidence set forth in Mr. Sawinski's affidavit. Prior to Mr. Sawinski contacting his attorneys in 2021, the defense states that it had no way of knowing that such an account of events existed. The log of the call that Mr. Sawinski made to the Manitowoc County Sheriff's Department was not turned over to the trial counsel in spite of numerous discovery requests. Neither trial nor appellate counsel was on notice that any such contact occurred. The record of the call was only delivered to current defense counsel after Mr. Sawinski contacted the team directly, and the team specifically requested records of any contacts between Mr. Sawinski and the Manitowoc County Sheriff's Department in order to verify the assertion made in the affidavit. Based on those facts, the defense has met the requirements and satisfied the second standard of the Edmonds test. In the third standard of the third standard of the Edmunds, that's what it says, requests that the defendant establish that the new evidence offered is material to an issue in the defendant's case. The evidence submitted as being material to the defendant's motion goes to this theory that a third person committed the crime for which the defendant was convicted of. For evidence to be admitted to establish that a third party committed a crime rather than the accused, the evidence must meet the test set forth in Denny. For evidence to meet the Denny test, the evidence offered must show that there is a legitimate tendency that a third party committed the crime alleged. More specifically, the evidence must establish that the third party had the motive, the opportunity, and a direct connection to the commission of the crime itself. While the defendant does not have to prove the guilt of a third party at the level that would sustain a conviction, evidence that simply affords a possible ground of suspicion against the third party is not admissible. The defendant asserts that the evidence in the Sawinski affidavit establishes a direct link between Bobby Dassey and the murder of the victim. By linking Bobby Dassey directly to the vehicle driven by the victim, the defendant asserts additional evidence previously discounted in this case may then be reconsidered by the court, further supporting his third-party suspect theory. The defendant argues that this previous excluded evidence includes a CD copy of the computer hard drive found in the Dassey home. The defendant argues that this CD, which contains searches of terms and subjects, including images of violent pornography, would establish a sexual motive for Bobby Dassey to have committed the murder. The defendant argues that the Sawinski affidavit also establishes that Bobby Dassey had the opportunity not only to have committed the murder of Ms. Halbach, but also to plant evidence, including the defendant's blood and DNA, in the victim's RAV4. Further, the defense argues that Mr. Dassey's possession of the RAV4 also provided to him access to the key of the victim's car, found in the defendant's home, as well as the victim's electronics found in the burn barrel along with the victim's remains. Sorry, I keep getting distracted by my phone going off constantly. The defendant finally asserts that the information in the Sawinski affidavit could impeach the testimony that Bobby Dassey gave at trial, in which he stated that the victim never left the property and was last seen heading towards the defendant's trailer. With respect to the motive element of the Denny test, the defendant argues that the state clearly considered that sexual assault was a motive for the murder, as evidenced by the seizure of the family computer in the Dassey home. The defendant asserts that evidence of Mr. Dassey's motive to commit murder was contained on the hard drive of the computer, which was copied onto a CD referred to as the Veli CD. The defendant cites the decision of the Court of Appeals in which the court stated that the content of the Veli CD may become relevant to the defendant's motion if the defendant could prove a direct connection between Mr. Dassey and the murder committed. The defendant then goes into a lengthy argument as to how the evidence found on the Dassey family computer. Notice how they keep trying to separate that computer from Bobby and make it a family computer. The Dassey family computer establishes the motive for Mr. Dassey to have committed the murder of Ms. Halbach. The defendant asserts that searches for words and images found on the Dassey computer show an obsession with violence and killing. The defendant further states that the images deleted from the computer were pornographic in nature and depicted violent images of the torture and mutilation of young females. The defendant then refers to the affidavit of Brad Dassey, the half-brother of Bobby, who states that he had a conversation with Barbara Dassey, Barbara is spelled wrong, Bobby's mother, in which she stated that she hired someone to delete the files from the computer in question. And now remember, Brad Dassey, people have a whole lot of stuff to say about Brad Dassey. And I hear you on some of it. But he also came forward right back then when there's nothing in it for him. The defendant hired an expert to examine the Dassey family computer. His expert, Mr. Hunt, states that he discovered 8 periods of time close to the date of the murder from which files were missing and presumably deleted. The defendant then states that Special Agent Thomas Fassbender examined the Veli CD and in his report described media that he found on the disk, images of the victim and the defendant with a date of April 18, 2006. Images of nudity of both sexes, including pornography depicting bondage and possible torture and pain. He further stated that other images on the CD included those of pornography, including acts between humans and animals, images of young women, and injured and mutilated people. Let me pause right here and go, they ripped Stephen's trailer apart. They destroyed that trailer looking for anything at all that could make Stephen look like a deviant, where they have pink fuzzy handcuffs that Barbara has the same ones because she and Stephen, I guess, got them together. So Bobby had access to those too, I guess you could say. So they want to take those handcuffs, anything to make it look like Stephen did something. Desperate. Look, tearing his place apart looking for pornography. Remember the one chick, what is her name? Wendy Baldwin? The one that's, you can hear her on the video saying, should we take his shoes? So if we have any other unsolved crimes? And he's not going to make it to the Innocent Project event. They were doing anything to find anything they could pin on Stephen. And they have nothing. There's nothing. There were some pictures of Stephen's girlfriend and a home video of Stephen and his girlfriend. All perfectly natural. Nothing wrong with that. Nothing. But you find all that on the Dassey family computer, and they say nothing about it. Oh, it's nothing. These aren't the droids you're looking for. The defendant then asserts that the record contains sufficient evidence to prove that Bobby Dassey was the only member of the household at home during certain days and hours when some of the searches were conducted. The defendant bases this conclusion on the self-reported routine schedules of all other members of the Dassey family that would have kept them out of the house at the time the searches were conducted. Based on those routine schedules, the defendant asserts that every other member of the family living in the Dassey house was excluded from conducting the incriminating searches, and that only Bobby could have searched these violent and pornographic images found on the family computer. The defendant asserts that he too must be eliminated as a person who conducted the searches because he has no access to the Dassey home and did not have the password to the computer. Pause. And he had his own frickin' computer. And if you're going to search those kinds of things, remember Stephen's girlfriend is in jail for DUI number whatever. So if you're going to look up these things, you're not going to go to your sister's house to do it. You would do it at your own home. So I know Stephen's niece, who likes to call herself the spokesperson for the family, likes to point the finger at Stephen, saying Stephen had access to the Dassey family computer. He wouldn't go to Barb's trailer to go look these things up during the day when Stephen's at work. Stephen worked. He wasn't just sitting at home doing nothing. He's the one Avery boy who did all this work at the salvage yard. He would take off for lunch every day and have lunch with his mom. There would be times he would get calls from his girlfriend in jail or have to deal with things where he would pick her up at the jail and take her to some DUI class. But he was working during the day, not going to Barb's trailer to go look this sick stuff up. And I find it disgusting that, again, the family is so desperate to keep pointing the finger at Stephen, and which also points the finger at Brendan, while then also telling supporters, give us money and help support us because we're Stephen's family. It makes me so mad. As further proof that he could not have conducted the computer searches, the defendant notes that most of the violent pornographic images discovered were accessed after he was taken into custody on November 9, 2005, and that Brendan Dassey, also convicted of crimes related to this murder, was in custody on March 1, 2006, when more of the most violent images were searched. The defendant further cites Bobby's testimony at his trial, in which he stated he was home alone and asleep from 6:30 a.m. to 2:30 p.m. on October 31, 2005. Because there were searches done on the Dassey family computer during those hours, the defendant asserts that the only conclusion that can be drawn is that Bobby conducted those searches. Now, I know something that they're trying to say is, well, these searches were done after the murder. Not all of them. Some of them are done after the murder. So why would that mean he did it? But it's establishing a pattern. So there were these searches prior to the murder, and then the searches afterwards. You know, there's something wrong with Bobby Dassey. You know, and so just because he murdered somebody doesn't mean he then stops looking that stuff up. And if this was Stephen's computer, oh my gosh, they probably would have executed Stephen. Does Wisconsin have the death penalty? They probably would have executed him. If they didn't have the death penalty, then they'd bring it back just for Stephen because they found this stuff on his computer. But no, it's Bobby Dassey's computer, so who cares? The defendant also refers to documentation of an interview of Bobby taken on November 17, 2017, in which he stated that the family computer was located on a desk in the living room of the Dassey home at the time. Bobby further denied that the computer was ever located in his bedroom. However, crime scene photos taken on November 12, 2005 show the computer in that location. The defendant further cites an affidavit taken on June 25, 2018, in which Bobby's brother Blaine stated that the family computer was located in Bobby's room and Bobby was the primary user. Based on that evidence, the defendant asserts that the violent pornographic images researched by Bobby were conducted sufficiently close in time and were sufficiently similar in manner to the murder to establish a motive for Bobby to have committed a crime. The defendant relies on Dressler versus McCautry for the proposition that other acts evidence admitted as evidence could be proof of a defendant's motive, intent, and plan to murder the victim. The defendant quotes the Dressler decision in support of his claim. Quote, "The fact that the defendant maintained a collection of videos and pictures depicting intentional violence is probative of the state's claim that he had an obsession with the subject. A person obsessed with violence is more likely to commit murder, and therefore the videos and photographs are relevant." Unquote. Based on the Dressler ruling, the defendant asserts that the court should find that Bobby's obsession with violent pornographic images made him more likely to have committed murder, establishing his motive in this case. In further support of his assertions, the defendant cites the report of his expert, Dr. Ann Burgess. Dr. Burgess states in her affidavit that there is a well-established causal connection between pornography consumption and violent behaviors. The defendant further refers to an affidavit submitted in a prior motion, submitted by former FBI agent Greg McCrary, in which he offered his opinion that searches for violent, underage, and child pornography, combined with images and searches for dead bodies, quote, reflects a comorbidity of sexual paraphilia, unquote. Agent Gregg further concluded that, quote, Bobby was becoming obsessively deviant in his viewing of violent pornography, unquote, in the weeks before Ms. Halbach's murder, end quote. All right. Pin in it. Let me put this to the top so I can easier find where I'm at. I haven't talked to Steven since his mom died. People constantly tell Steven bad things about me and want to control him. So I don't talk to him anymore, but I used to. Okay, I used to visit him in the prison. I'm trying to turn this so you can see it, but the light is crappy. There you go. There's one visit with Steven. And here's another visit with Steven. Okay. I'm really bad at trying to get this so you can see it. Can you see it here? Okay. There's another visit. On a visit with Steven. And this is in my book, too. Buy my book on Amazon. He told me that, or maybe he told me on a phone call. Don't hold me to that. I can't testify to that he told me in person or on a phone call. That, because see, Teresa Halbach had been to the salvage yard multiple times because Steven, hello, my sexy girlfriend Miley's here. Hi, Miley. Teresa had been there multiple times because Steven would fix up vehicles and sell them. Makes perfect sense, right? So Teresa had been there a couple of times. And so he told me that Bobby commented to him several times, knowing that Teresa was going to be there and was calling her Steven's girlfriend. But he was like obsessed with knowing, oh, and there's Kat. Obsessed with knowing when Teresa Halbach was going to be there. And he knew in plenty of advance notice that Teresa Halbach was coming this day, since now it was his mom's van that was being sold. And the boys were told to clean that van out for the pictures. And the boys were also mad about the fact that that Barb was going to sell that caravan because they wanted to keep it as just something they drove around or whatever. So Bobby knew in advance. I almost said Bryce. Bobby knew in advance that Teresa Halbach was coming that day. So premeditated? Don't know. All right. The state disputes the conclusions drawn in the defendant's argument, asserting that the defendant is misrepresenting the facts of the case. The state argues that the defendant has fallen short of establishing that Bobby Dassey was, in fact, the person who conducted the computer searches in question, or that the searches conducted were probative. Oh, and Debbie's here. Or relevant to prove that anyone had a motive to commit murder in October of 2015. We are now on page 13 of 31. We're not even halfway. Oh my God, how long have I been on here already? Almost an hour. The state argues that, once again, the defendant failed to establish that Bobby Dassey conducted any of the searches cited by the defendant. Referring back to a previous decision issued by the Court of Appeals, the state recounted the court's conclusion that the mere fact that Bobby could have been home alone when some of these searches were conducted was not conclusive evidence that he did in fact conduct the searches. The defendant, the court continued, cannot rely on the opinion of a computer expert or anyone else's speculation as to what Mr. Dassey's actual schedule was. I haven't read this in advance, so sorry if when I read something I start to get mad. Of what Mr. Dassey's actual schedule was on any particular day in question. and a fact which applies to other family members as well. The state notes that there are no citations to any facts of record establishing Mr. Dassey's whereabouts at the time the searches were conducted, or any evidence that conclusively established that no other person had access to the home or computer at the time in question. Furthermore, the state notes that the defendant provided no citations of record to specific images that would directly relate to the crime committed or identify how any of the images were relevant to any specific individual having motive to commit murder. Referring again to the Court of Appeals decision, the state notes that the court previously concluded that the existence of the searches during a time that Mr. Dassey was usually at home is not a fact that would establish conclusively that he was actually in the home at those times, let alone that he was the person using the computer of accessing these images. How many people do you think are sitting in jail or prison on that very thing of somebody just saying this is somebody's typical schedule and they're usually home at this and such a day? But in Bobby Dassey's case, again, it's don't look here. Look at Stephen. Just look at Stephen. Don't look anywhere else. The state further disputes the defendant's conclusions that law enforcement considered pornography or sexual assault as a motive for the murder in this matter. The state notes that during any criminal investigation, law enforcement collects all potential evidence that could possibly be relevant to the case. The evidence is then analyzed for determination as to whether it has any bearing on the crime committed. The mere fact that the investigator seized a computer does not prove any theory of the case. The state asserts that any relevance assigned by the defendant to the seized computer is unsupported speculation. So I again just have to rant about what is Stephen's motive? Tell me what Stephen's motive is. Why would he, if he's going to kill somebody, why would he kill some random woman coming to take a picture that there's a paper trail that she's going to be there? And if you're going to say his years of sitting in prison, his 18 years of being in prison for the Penny Bernstein attempted rape, made him angry, which who would blame him if that would make him angry? Because there was plenty of evidence to show that Stephen was innocent of that. So sure, you're angry. Why would he murder some random girl that had nothing to do with him being in prison for 18 years? And at this point, he's been free for 2 years. He has a girlfriend. I know Jody's a horrible person, but that's who he loved, and that's Stephen's choice. You know, you love who you love. So he's happy with his girl. He was about to get a couple $100,000 from the state. And the depositions just started in his wrongful conviction that he was suing for $36 million, $2 million for every year that he was in prison. Why is he angry? That he's just going to then kill some random girl. Jody was not in prison. Jody was in jail. He would pick Jody up. She's able to leave the jail to go to these classes. He regularly saw his girl. He regularly talked to his girl. We've done videos of listening to his jail calls, and you've heard some of them on Making a Murderer. And the one that always stands out to me is when he's talking to Jody, and when they were talking about if he would propose to her, and she's, wants it to be romantic. And he's like, oh, romantic? Listen to his voice. And that call in particular is also when they claim he's stoking the flames of Teresa Halbach in a fire. Listen to his voice and listen to him talking to his girl about getting married. And he's happy. Oh, romantic? Oh, I'm stoking this fire of this girl that I just killed. Not telling you I can't talk now. I've got a body to cover up. And something that I talked to Steven about that I find pretty major. Back at this time, when Jodi was in jail, they only allowed her to call landlines. She could not call a cell phone. And there's Kat talking about that. Because, we've been talking about these things a million times over the years. So for you new people who maybe haven't heard these things, so he's on a landline. Yes, he's on a cordless phone. It didn't reach where that fire pit was. And I asked Steven how far could he get from his trailer with that phone. And he said he couldn't even go to his driveway and still have reception to talk on his landline cordless phone. So, how is he tending to this fire and talking to Jodi and having no annoyance, no angry, no trying to hurry up, none of that? Because also, if you listen to all his jail calls, you hear when he's angry with family members or just angry to family members, because these are who you're going to vent to, right? So Steven can clearly be agitated and have an attitude. And so if he just raped and or cut her hair, punched her face, cut her throat, whatever, all these different scenarios between the Stephen Brendan convictions, he would have been annoyed, because Jodi also called him a lot. And I get the calls, because then Steven called Dolores a lot. You're in jail. You're miserable. You want to talk to the people you love and trust. But Steven would have clearly not taken her call, or he would have been in a pissed off mood, don't you think? Not, ooh, romantic. Not happening. All right, back to where we were. Page 14 of 31. The state also argues that the images and terms found during the computer search and cited by the defendant as evidence of motive for murder are not similar to what actually occurred during the commission of the crime and are not relevant to proving motive for anyone, including Mr. Dassey. The state asserts that someone having conducted a search for terms like news, body, journal, and cement, which are very general and not specifically related to this crime. Well, we don't know that, because we don't know everything that happened in this crime. The state notes that the defendant's own exhibits show that the majority of the searches for pornography and violent graphic images have no direct similarity to the manner in which this crime was committed. Well, but what about whatever was deleted? The state further points out that most of the searches referred to by the defense occurred on a weekend when anyone in the house could have accessed the family computer, while other searches occurred after 3:45 p.m. on a weekday when Blaine would have had access to the computer as well, not in Bobby's bedroom. Additionally, the state points out that the defendant's timeline, in which he asserts that Bobby was the only person who could have conducted the searches, does not account for the time when Mishicot School District spring break took place. Between March 24, 2005 and March 30, 2005, Blaine, Brendan, or anyone invited over by the boys could have accessed the computer. in Bobby's room, probably with the door shut and the boys told they can't go into Bobby's room. Between April 7, 2006 and April 18, 2006, Blaine had access to the computer as well, again in Bobby's room. The state goes on to argue that, of the 128 searches listed and relied upon by the defendant as evidence of motive, only 28 of those occurred. Only 28, just a mere 28 of those occurred during the time that it is alleged that only Bobby Dassey could have accessed the computer. Only 28, no big deal. 28 different searches of violent pornography and killing women, raping babies. Oh, only 28. Huh. Furthermore, of those searches, only 3 of the searches occurred prior to Ms. Halbach's murder. Assuming for the purposes of this motion that those 3 searches, only 3, you'll find 0 on mine, just saying, were conducted by Bobby Dassey. The state argues that a mere 3 searches conducted prior to the murder of Ms. Halbach failed to demonstrate that Mr. Dassey was a voracious consumer of violent pornography prior to the murder, thus failing to establish the theory of motive offered by the defendant. It's more of a motive than Stephen has. What is Stephen's motive? You have no motive. Stephen was there. Bobby was there. What's Stephen's motive? Addressing the defendant's citation of Dressler versus McCautry, the state argues that the defendant's reliance on this ruling is misplaced for a number of reasons. First, the state argues that the ruling in Dressler was made in a habeas corpus proceeding and is not binding in Wisconsin criminal law. Second, the state argues the facts in the Dressler case present a vast departure from those in the case before the court. In Dressler, the male victim was murdered in an extremely specific manner that included binding, mutilation, and dismemberment. While investigating the crime, law enforcement searched the defendant's home and discovered many weapons and restraints, along with pictures, magazines, and videos depicting similarly murdered and mutilated victims, as well as homosexual pornography. Because, oh my God, homosexual pornography must mean you're a killer. I digress. These items were offered at trial as other acts evidence in support of proving the defendant's intent, motive, and plan to assault and kill the victim in the specific manner depicted in the images found in the defendant's possession. The state argues that the facts in the case at bar and those in Dressler are substantially different. Yeah, cases are different. I don't like that you have to find another case that is like yours. Not everything is the same. In Dressler, the state notes that there was no dispute that physical evidence belonged to the defendant and was in his exclusive possession. In this matter, the state argues that the defendant has not provided any facts to prove that Bobby Dassey was the person in possession of the pornography alleged to be the motive for the murder or had exclusive access to the computer. In addition, the pornographic images discovered in the Dressler case very closely mirrored the evidence discovered at the crime scene itself. The state argues that the defendant neither submitted any images taken from the Dassey computer that show an individual who was shot and burned, but also we don't know if Teresa Halbach was shot and burned. We don't know what happened to Teresa Halbach. So why would Bobby, the killer, need to be looking up shot and burned if there's nothing proven that Teresa Halbach was shot and burned? Furthermore, the state agrees that the search terms cited as evidence of motive for murder are general and do not specifically relate to the crime committed in this matter. Finally, the state notes that all of the violent images and pornography found in the Dressler case were in the exclusive possession of the perpetrator before the murder occurred. The media evidence in Dressler, the state argues, showed a prior disposition to commit the crime and a great similarity to the actual crime scene itself. because the evidence was in the possession of the defendant prior to the crime having been committed, the state argues that it did in fact demonstrate a motive, plan, and intent to commit the crime as alleged. In the case at bar, the state points out the vast majority of the computer evidence relied upon by the defendant to prove Bobby's motive to kill was obtained during searches conducted after Ms. Halbach was murdered. The state further states that the images and search results from the Dassey computer did not directly mirror the manner in which the victim was killed. We don't know how Teresa Halbach was killed or if she was killed. Unlike the defendant in Dressler, the state notes that evidence offered by the defendant as proof of motive cannot be proved to have been obtained by or have been in the sole possession of Bobby Dassey. Kathleen Zellner does not have to prove who killed Teresa Halbach and why and how. She just has to show that there's other things that should have been looked at and that Stephen, there's no evidence to prove that Stephen did it. Her case is to her job is to defend Stephen Avery. So by saying that these things being on Bobby Dassey's computer, it's in Bobby's room, it's Bobby's computer, Bobby Dassey's computer, is a suggestion of motive. It's not saying it was the motive. We don't know until Bobby Dassey finally admits it, or his friend Michael Osmondson, who knows what happened, or even helped after the fact, speak up. We won't know unless any of these people finally crack. Don't know. So having that on Bobby's computer is something you could see as a motive, since they're desperate for a motive. You can't talk about Bobby Dassey unless you can prove there's a motive. Well, here are things that could be a motive. Not saying it is a motive. Could be. We're on page 17 of 31. To the extent that the defendant's submission establishes anything, the state alleges that it demonstrates the defendant cannot meet the admissibility standards under State v. Sullivan. The court in Sullivan ruled that for other acts evidence to be admissible, the evidence must be submitted for a permissible purpose, it must be relevant, and that its probative value must not be outweighed by unfair prejudice. Unfair prejudice. While motive is permissible purpose for which evidence can be used, the state contends that the defendant has not established that the evidence he offers is relevant to this matter. The state notes that the Court of Appeals has rejected the argument that the images on the Dassey computer depicted any situations that were similar to the crime scene in the Halbach murder. Where's the crime scene? Is it Stephen's bedroom? Is it the garage? Is it the burn pit? Was it the candlestick in the library? Where's the crime scene? Where's her blood? Where's her hair? Where's bodily fluids? If you're raping her, and Brendan's raping her, stabbing her, cutting her hair, two guys ejaculating, or maybe they didn't. Where's pubic hairs? Where's anything? You have nothing. Trying to find where I was. The state argues that there is nothing about the evidence found on the communal family computer in Bobby Dassey's room that you then lie about and say wasn't in Bobby's room. That's not suspicious at all. Depicted any situations that were similar to the crime scene in the Halbach murder. The state argues that there is nothing about the evidence found, I just read that, on the communal family computer that is relevant as to proof of motive prior to the commission of the crime. The computer information was collected long after the murder. long after the murder. Long after the murder. So Bobby Dassey is the last person to see Teresa Halbach alive. They removed the Halbach family, or the Avery family, from their property. Wouldn't even let Dolores go get her medication. And you're not looking at the computer until long afterwards of the last person to see Teresa Halbach alive. Gotcha. Nothing in the evidence submitted, the state asserts, makes it more or less likely that Bobby Dassey committed the murder as the defendant alleges. The state also argues that because there is a lack of similarity to the crime committed and that the searches were done after the crime was committed, the prejudicial value of the evidence offered outweighs its probative value. Because there is no direct link to motive or any evidentiary similarity between the computer evidence and the crime committed, the state argues that a jury could convict Bobby Dassey on legally inadmissible evidence. If such evidence were submitted to the jury, the state argues that a jury could conclude that the individual who searched for such images was inherently a bad person and convict on that basis alone rather than on applicable law. Which, how many people again are in prison for that? Do you think it was premeditated for Bobby to kill Teresa Halbach? They say all these things that he would have had to have done all these searches prior to the murder. But that's only if you think it's premeditated, that Bobby was just saying, I'm going to murder this bitch. But what if it was more like Bobby had a crush on Teresa Halbach? Because he was noticing every time she was there, so he's mentioning it to Steven, knowing she's coming. So, what if he started talking to her about a hustle shot? Because remember, Teresa Halbach was paid by Auto Trader $10 per vehicle that set up the appointment through Auto Trader. She would get $10. If she found the client and gives it to Auto Trader on the silver platter, here's their paperwork filled out and I've already taken the pictures, she gets $20. So Teresa Halbach anybody would much prefer you just make the appointment with me directly. Double the money. Steven Avery had her cell phone number. Yet, when he makes this appointment, he does it through Auto Trader, giving a record that he called. So Bobby knows she's going to be there that day because Mommy tells him to clean the van. So what if he stops her, trying to make some conversation with her, and talks about a hustle shot, and then he, however, could be innocently asks her out. Maybe he wasn't so suave and made a vulgar pass at her. And she rebuffed him, whether or not it was like, oh, no, he's younger than her. She's sorry kid or whatever. And then that makes him angry in a spur of the moment. So he's just first thinking he's going to hit on this chick. And then however she turns him down, he gets mad, and now he does whatever he does to her. He's the last person to see her alive. So after he then commits this murder, rape, whatever he did to her, maybe then he starts searching things to compare to what he's done. Just saying. A review of the record and the defendant's argument reveal that he has failed to satisfy the third standard of the Edmonds test, as well as the motive element of the Denny test. With respect to the Edmonds test, the defendant argued that the evidence offered was material to an issue in the case because it established that there was a viable third-party suspect that could have committed the murder of Ms. Halbach, and such evidence was never presented to the jury for consideration, undermining confidence in the verdict reached. In order to meet that burden, the defendant had to prove that the evidence also met the standard set forth in Denny to be admissible as proof of a third-party suspect. The defendant failed to establish that Bobby Dassey had the requisite motive to commit the murder of Ms. Halbach. Again, I say, what's Stephen's motive? The defendant rests his motive arguments on the premise that Bobby Dassey had an obsession with violent sexual pornography involving young women and a fascination with gruesome homicides and deaths. However, the defendant's arguments are not supported by the evidence submitted. As the Court of Appeals has already concluded, the defendant did not establish that it was Bobby Dassey who conducted the searches in question. The Court of Appeals ruled that even if the defendant is correct as to what the usual schedules of the Dassey family members were, those general schedules are not proof establishing where any specific member of the family was on any given day. I beg to differ. Their stuff's like clockwork. What they work till this time to this time, they're home at this time, lunch this time. Oh, but Bobby and Scott know the exact time they did the crisscross. When Bobby's going to go hunting on Scott's property, and Scott's going hunting somewhere else, not on his own property. But they happen to remember that exact time that they saw each other. While the defendant argues that nothing short of a recording of Bobby Dassey conducting the searches on the computer would satisfy the standard of proof demanded by the state, this assertion is not true. Oh, it's so true. The defendant could have offered any piece of evidence that, during the time in question, Mr. Dassey entered some type of identifier unique to him, such as a specific username or password to identify that he was, in fact, the person using the computer to conduct the searches cited. The defendant could have offered a witness who saw Mr. Dassey actually conducting any of the searches in question. You know, all those witnesses when Bobby's the only one home. Everybody else is at work or school. You know, those witnesses. Even more simply, the defendant could have offered evidence that the defendant was actually home at the time of the searches rather than speculation based on the typical schedules of the family to prove that Mr. Dassey conducted the searches. The Court of Appeals has already concluded that the mere fact that Mr. Dassey may have been home during the time that the searches were conducted was not conclusive proof that he was the person who actually conducted the searches that the defendant relies upon to prove motive for murder. The defendant's reliance on Dressler is also misplaced. The facts in Dressler were substantially different from those in the current case. Again, hate this. The defendant in Dressler was shown to have very specific images in his possession that closely mirrored the evidence found at the crime scene. The instruments involved in the murder were found in the defendant's exclusive possession. What are those? What instruments were found exclusively in Stephen's possession? How do you know when Stephen's at his house? How do you know that Bobby doesn't have access to his trailer to have access to the Glen Glenfield rifle, Raleigh Johnson's rifle that was hanging in the gun rack in Stephen's bedroom, owned by Raleigh Johnson. Almost everything in Stephen's trailer was owned by Raleigh Johnson. Who Raleigh Johnson had access to that trailer and had access to that gun. And Barb would have access to that trailer, and Dolores and Ellen and Chuck and Earl, all of them have access to Stephen's trailer where all these alleged instruments involved in the murder were. Because if you're going to say anybody had access to the Dassey trailer, so anybody could have put that stuff on the computer. Anybody could have gotten that gun out of Stephen's trailer. Anybody could have put that bullet casing in Stephen's garage. See how that goes both ways? In this case, the images and terms searched by someone in the Dassey house on the family computer do not closely mirror either the method of murder or the disposal of the remains in this case. Again, tell me what method of murder. Because what you convicted Brendan on is totally different than what you convicted Stephen on. So what method? The searches offered by the defendant refer to generalized violent pornography. We're now on page 20 of 31. I have to leave in a half hour. Violent pornography and term searches. No search results offered by the defendant directly mirror the elements of the crime in this case. There is no evidence, only generalized assumptions, that Bobby Dassey was the individual who conducted the searches on the family computer. I'm adding those quotes. The computer was not in the exclusive possession of Bobby Dassey, even though it was in his bedroom, prior to or after the murder. Only a small number of searches were conducted. Prior to the murder of Miss Halbach. No physical evidence directly linking Brian Dassey to the homicide was found in the house. Why are you talking about Brian Dassey? And you're spelling Brian Dassey wrong. Okay. The defendant offers the argument that Bobby Dassey had a predisposition to commit the crime based on an addiction to violent pornography. The defense offers two experts who discuss the role of pornography in the commission of this crime. Putting aside any questions as to the qualifications of the experts to opine on this matter, both of the conclusions reached by the experts depend on the assumption that Bobby Dassey was the individual researching the pornography on the computers. It has computers plural. Is that a typo, or is there another computer that's missing that nobody knows about? Just saying, I can't trust them as far as you can throw them, right? A fact not established in this matter. Furthermore, the experts reached their conclusions without doing any forensic or psychological examination of Bobby Dassey in person. Their conclusions as to his mental state are based on evidence that is not admissible in this matter. Then what is the point of ever having experts? There's experts all the time that don't talk to witnesses or the accused or whatchamacallit, or killed. So why in this case now don't listen to these experts? Furthermore, the experts reached... Oh, I already read that. Sorry. Squirrel. The defendant has not met the burden under Denny to establish that Bobby Dassey had motive to commit the crime alleged and, as such, failed to meet the burden to admit the evidence offered to prove the existence of a third-party suspect for the commission of this crime. Without such a finding, the defendant cannot meet the third element of the Edmonds test, establishing that the evidence is material in his case. As previously noted, evidence that simply affords a possible ground of suspicion against a third party is not admissible. Going on to page 21 of 31. Even if the defendant had met the burden with respect to the motive element of the Denny test, he has not met the burden with respect to the element of opportunity under the same test. The defendant asserts that the legal term of opportunity is broad and encompasses other acts of evidence that may otherwise be inadmissible. The defendant states that the opportunity can include the individual's physical presence at the crime scene or proof that an individual had the requisite skill, capacity, or ability to carry out an act. The defendant also notes that it is incumbent on the proponent of the evidence to show the relevance of the evidence offered. The defendant notes, I have this freaking fruit fly that keeps flying around my face. The defendant notes that Mr. Dassey was present on the Avery family property on the day that Ms. Halbach's murder took place. We don't know that's the day her murder took place if there's a murder. The defendant then refers to the affidavit of Mr. Sawinski to further support his other arguments. The defendant argues that the affidavit of Mr. Sawinski establishes that because Bobby had possession of the RAV4, he, therefore, had access to evidence that the defendant asserts was planted to frame him. Specifically, the defendant asserts that Bobby's possession of the RAV4 gave him access to the key found in the defendant's home and the victim's personal electronics found in the burn barrel. The defendant further states that Mr. Dassey had access to his blood because, on November 3, 2005, the defendant reopened the cut on his finger and dripped a substantial amount of blood in his bathroom sink and on the bathroom floor. The defendant then states that he went to the Dassey residence to ask Bobby and his brothers if they would like to go to Menards with him and his brother. According to the defendant, Bobby decided to stay behind. It was also at that time that the defendant states that Bobby saw the open cut on his hand. The defendant states that when he left for Menards, he left his trailer unlocked and upon leaving saw the taillights of a vehicle near his trailer. Pin in it. This is the only thing that I disagree with Kathleen Zellner on. I do not think Bobby Dassey planted the blood in Teresa Halbach's RAV4. I still believe Manitowoc Sheriff's Department did that. And I believe that Manitowoc also planted the key. Blank and Colborne planted the key. And I think that's the spare key that they got from Ryan Hilgas, Scott Blodorn, and Michael Halbach. What Bobby did with her key, I don't know. Because her actual key has never been found. It's only her spare key. So I believe they got the spare key from Scott Blodorn, Ryan Hilgas, and Michael Halbach. And I believe they told those guys that due to the $36 million lawsuit, that Stephen was guilty of this and he's going to get away with it because of this other thing. So they needed something concrete to prove it was Stephen. So I think those boys thought that they were helping frame an innocent man. And for that alone, if that was it, would I fault them for that? What would I do if it was my loved one? Maybe, right? But after watching Making a Murderer, they can lie and say they've never watched Making a Murderer. They have. And you see and hear all this stuff. All you should care about is what happened to Teresa. Not this mistake was made and now we have to double down and keep him in there. You should care about punishing who really did it. So I believe that the sheriff's department planted the blood and the key and the magic bullet that has no dust or DNA on it. That was rubbed with chapstick. Oh, for that DNA on the chapstick. Yeah. Sorry. Okay. I think this is where it was. However, in the matter before the court, we're on page 22 of 31. The state argues that the defendant is offering a much more complicated scenario as to Mr. Dassey's opportunity to commit the crime. Referring to the defendant's argument, in order to satisfy the Denny test, the state asserts that the defendant must offer evidence that Mr. Dassey had the skills, contacts, tools, time, and or other means necessary to have committed the crime and staged the scene in the manner alleged. The defendant must provide, quote, evidence that the third party had the realistic ability to engineer such a scenario, unquote. The state argues that the defendant failed to meet that burden in this matter. The state asserts that the defendant had offered no evidence to establish that Bobby had the opportunity to successfully orchestrate this extremely complicated scheme to frame his uncle. The state argues that the complete absence of any necessary facts to support the defendant's argument demonstrates that the defendant has insufficient evidence to show that Bobby had the opportunity to kill Ms. Halbach and frame the defendant in the manner the defense claims. She's giving a scenario. It's not saying it happened factual, that this is what happened. Same thing they did to Stephen. The state goes on to argue that the defendant has offered no evidence to establish that Bobby... Oh, I read that already. Wait, no, I didn't. That Bobby had the necessary skills available to manipulate the evidence in a manner that would implicate the defendant. The state notes that at the time of the murder, Bobby Dassey was an 18-year-old high school graduate with no criminal record. What's Bobby Dassey's IQ? We know that many of the Avery family don't have a very high IQ. Or as Earl calls it, Earl spells IQ, ICIOO. Just saying. I have the text to prove it because he texted it to me. Stephen's got a lower IQ than Brendan. Stephen was 22 years old when they took him for Penny Bernstein. Did Stephen even graduate high school? I don't even know. I don't recall. So Stephen has a low IQ, goes to prison when he's 22 years old, gone for 18 years. He's not getting educated in prison. Is only out for 2 years and put back again. So you're trying to say that then Stephen is smarter than Bobby just because one is older than the other. Rebecca says, nope, Stephen dropped out of school to help on the yard. So why does it automatically make Stephen smarter than an 18-year-old boy who doesn't have the low IQ? Mr. Dassey was employed as a third shift worker at a furniture factory. The state posits, is that how you say that? That there is no evidence of record that establishes how an individual of Bobby's age and experience would have obtained the scientific knowledge or skill to collect, transport, and plant the defendant's blood from his bathroom. I don't think Bobby did. But nobody's investigating it. Thank you, Rebecca. At 15 or 16, it's talked about in Making a Murderer that Stephen dropped out. The state notes that nothing in the record indicates how Mr. Dassey would have obtained the necessary materials to collect and transfer evidence in a matter successfully, as well as in a manner not detected after analysis by the crime lab. The state points out that the defendant, in his brief in chief, does not address how Bobby transferred touch DNA to the victim's car. And there's a long footnote. In his response brief, the defendant asserts he previously explained that the touch DNA was transferred by law enforcement from an illegally obtained swab of his person. However, the defendant also speculates that Bobby could have taken his toothbrush from the bathroom and used the DNA from that to place the DNA on the victim's car. This is a new claim. The defendant has not previously mentioned a missing toothbrush in his previous motions. He did tell his lawyers. Or attributed such action to Bobby Dassey. It is not clear from the defendant's argument which scenario the defendant is now relying upon. That both Bobby Dassey and law enforcement independently attempted to frame the defendant, or that he is abandoning his theory of law enforcement involvement in the planting of evidence and speculating on the theory that a toothbrush provided the touch DNA on the car. Let me see. Is this right here somewhere? Hold on one second. I never know where I put things to try and remember them. Remember in Making a Murderer when there was the big aha, they found that blood vial, and then they can see that the box that that evidence was in had been tampered with. And then there was the big deal about the holes on the top. And they were trying to say that that would mean that somebody put a needle in there. And then it was dismissed as that standard procedure with those vials. Right? Well, in 2017, my husband has the same vial and drew his own blood and put it in here. I have pictures posted from when he did that. And when he did that, there was clearly a hole at the top of this vial. He did that in 2017. It is now 2023. I don't know if I can show this to you that you'll see. There's no hole on here anymore. It's completely sealed shut that you don't see that a needle's gone into here. And my husband, who put his own blood in here, it's dried up. It didn't stay liquid. But this is the same thing. There's no more hole here. So the hole doesn't stay for all those years. So for you to be able to see a hole in this vial, it had to have been a needle put in there recently. No hole. All right, back up. Furthermore, the state notes that the defendant does not explain how Bobby could have kidnapped and killed Ms. Halbach, then hid her body and her car within minutes of being seen on the highway at approximately 3 p.m. Wait, who is that saw him at approximately 3 p.m.? Is he saying that was when he and Scott Taddock did the crisscross? Or is it going to be when his brother Blaine is in an affidavit that he saw him when he was going home on the bus, Bobby driving the RAV4? Which being seen on the highway at 3 p.m. is that? Referring to the record, the state asserts that it contains no explanation or evidence to establish how an individual with Bobby's age, education, and experience, it's called the internet, discovered a tiny, mangled bullet fragment that he knew had the victim's DNA on it and planted it in the garage, or alternatively, shot the victim there on the 31st. We don't know if she was shot or if it happened on the 31st. And managed to thoroughly clean up the scene without the defendant noticing Bobby, even though he was using the garage to work on vehicles during and after that time. That garage is a freaking pigsty. Dust everywhere. They searched, and I'm sure you've seen the pictures of what they did to the trailer. They destroyed that trailer, ripping it apart. They looked in that garage. There was no casing there. But then how long later? I have forgotten. I have forgotten more than I remember on this case. Um, but when they find this bullet months later, was it a year later? I don't even know. I don't remember. Um, there's no dust on it. In a garage that's just sitting there. No dust on that. Perfectly preserved. Kathleen Zellner shows you in in the second episode, second series of Making a Murderer, whatever they want to call it, that and Raleigh Johnson testified to shooting at the garage all the time. It's Raleigh's garage. It's Raleigh's gun. He can shoot whatever he wants. They claimed on that casing there was a red color on there. Didn't say it was blood. Stephen's garage is red. So, hello. The state additionally argues that there is nothing in the record explaining or supporting the theory that Bobby moved the victim's body and burned it at some undisclosed location, then moved the bone fragments from almost every bone in the human body back to the burn pit on the Avery property undetected. While the defendant asserts that Bobby planted the key to the victim's RAV4 in his trailer between November 3rd and November 5th, the state notes that there is no explanation as to how Bobby could have moved the car from the property without the keys. He works at a salvage yard, and I don't think this happened, but you're telling me somebody who lives at a salvage yard wouldn't know how to start a car without a key? That's what they're trying to say there? Okay. The state notes that there is no explanation as to how Bobby could have moved the car from the property without the keys, driven away from the property, walked back to the property, and replaced the keys in the defendant's trailer without anyone noticing. I did a video that I actually ended up having to go to court for, because Chuck Avery had Josh Redant report me for trespassing, or as Earl calls it, trust passing, because I went to Cuss Road and then I went to in through the deer camp, and showing you on the video how close Avery Salvage Yard is to Cuss Road. If you have to drive the street and you're going around all the land, it takes a little longer than to cut through from Cuss Road, through the deer camp, through the quarry, through the salvage yard. There you go. And that's how you would be undetected. Duh. The Wilson test, I gotta leave in 15 minutes, and I'm on page 24, 34, or 31. Let's do this. The Wilson test requires that the defendant must provide evidence that Bobby Dassey had the realistic ability to carry out the complicated plan that alleges was used to frame the defendant. The defendant speculates on many points as to how Bobby could have carried out the plan to frame his uncle, but the Wilson test requires more. The defendant has failed to offer any evidence that Bobby had the scientific knowledge to recognize the significance of each piece of the forensic evidence supposedly planted by him, let alone establish that he had the skill to plant the evidence in a way that would stand up to scientific scrutiny by professional crime scene analysts. The defendant offers no evidence supporting his claim that Bobby had the requisite knowledge to create and execute an elaborate plan to commit a murder and frame his uncle. Okay, if you're going to talk about the bones, Um, there's the quarry, and then what's the other one called? Oh my God, I'm blanking on the two. Quarry and the other one. One is owned by Verdant, and one is owned by Manitowoc County. And there were bones found at the Manitowoc County one. So, what is perfectly understandable is that Bobby then took her body to the county quarry or whatever it's called. And I've driven through there. It's huge. There's lots of areas you could hide in there that people aren't going to see. Big, huge trees that you could park a whole car underneath and people wouldn't see it. So he could have burned her there, right? And then he's using the burn barrels. The family all, the weekend prior or after this alleged crime, everybody's gone. But Bobby and Earl. So Bobby could have been used because, stuff was found in his own burn barrels. But don't pay attention to that stuff was found in his burn barrel. Only pay attention to what's in Steven's burn barrel. That now when it's decided framing Steven, because if this is not a planned out thing and you killed the girl and now you're trying to come up with something, you're scooping bones into the burn barrel. You're not being scientific about it. You're just shoveling bones into a thing, and some got left behind there. That then years later, the frickin' state gives to the Halbach family. So you prosecute Steven on saying Teresa Halbach never left. And Steven never left. Let's not look at these bones that were found over here at the Manitowoc quarry. Gravel pit. Gravel pit. One's a quarry and one's a gravel pit, right? That's what it is. Let's not talk about that. Okay? But then years later, you're giving it to the Halbach family. But that has nothing to do with the case. And that's evidence in Steven's case. You're not allowed to just give away evidence in Steven's case unless Steven gives you permission. Steven did not give you permission to do anything with the evidence in his case. If that's not Teresa Halbach, right? You're prosecuting him saying anything that's found at the gravel pit is not Teresa Halbach. So why did the state give those bones to the Halbach family years later? What year was that they gave it to the Halbach family? I'm trying to find where I was. I'm so bad at this. I'm just going to start reading from here, and hopefully this is where I was. The Wilson test requires that the defendant must provide evidence that Bobby Dassey had the realistic ability to carry out the complicated plan that it alleges was used to frame the defendant. The defendant speculates on many points as to how Bobby could have carried out the plan to frame his uncle, but the Wilson test requires more. Wait. Okay, no, I read that paragraph. Sorry. The defendant further failed to offer any facts of record that establish a consistent plan to frame the defendant or any theory including or excluding law enforcement involvement which implicates the defendant in this crime. The defendant's theory that Bobby framed him for his murder also fails to acknowledge a significant fact in relation to this crime, to which Brendan Dassey confessed, and Brendan has nothing to do with Steven's case. Nothing! You did not use Brendan in Steven's case, so you cannot use him now in any post-crap. To which Brendan Dassey confessed and was convicted of participating in the murder of Ms. Halbach. Brendan specifically implicated the defendant in this crime, not in Steven's crime. I'm getting mad. And his conviction has been affirmed by the appellate courts and remain of record, but not in Steven's case. All of the allegations implicating Bobby in the murder and the framing of the defendant are pure speculation and not supported by any evidence submitted by the defendant. As such, the defendant failed to satisfy the tests in Edmonds, Denny, and Wilson. Finally, the defendant asserts that the Sawinski affidavit supplies a direct connection between Bobby and the murder of Ms. Halbach. The defendant asserts that because Bobby was in possession of the victim's RAV4, it proves that he had access to the key to the defendant's car and her electronics that were found in the burn pit. These items are links that are central to proving Bobby Dassey's involvement in the murder of Ms. Halbach. The defendant argues that Bobby's possession of the car provides a direct evidentiary link between Bobby and the crime committed, making him a viable third-party suspect. Yep. Assuming for the purposes of this motion that everything averred to in the Sawinski affidavit is true, the defendant is incorrect in his assertion that the facts in the affidavit provide a direct link between Bobby and the Halbach murder. The defendant asserts that, ipso facto, if Bobby was in possession of the victim's car that night, he must also have been the individual who committed the murder. No evidence submitted by the defendant supports this conclusion. But Bobby is the key witness against Stephen. Why didn't Bobby say he was pushing the car for his uncle? If he's going to be testifying against his uncle and helping put his uncle and his brother away, why wouldn't he say, and Stephen made me move her car? Even if Bobby was found in possession of the victim's automobile on the night of November 5th, 2005, there is only speculation and no evidence to prove that Bobby was in possession of the car or that he had exclusive control over the vehicle prior to that night. I fucking hate legal semantics. My God, I have to leave in like 5 minutes. But I served on a jury once. It was possession of an illegal narcotic with the intent to deliver. It was a drug dealer. The guy's totally guilty. We had audio, we had video. It was a total sting thing. The guy was guilty of trying to sell this cocaine to an undercover cop. There were people on the jury. It actually took us 2 days because there were people saying that the legal definition of the word possession means you have complete control over it. And since this was a setup with the police, that there were police at all the driveways, the entrances to this parking lot that the deal was going on, if the drug dealer had decided at some point that I don't want to do this deal and gonna leave, the cops wouldn't have let him leave with it. So therefore, he cannot legally have possession and is innocent. Idiots. Don't give me this possession crap. The defendant further asserts that Bobby's possession of the car gave him access to the victim's car key and her personal electronics. Again, this is speculation by the defendant. It is speculation that Stephen is the one that did anything. In Stephen's case, remember, no Brendan. There's no Brendan. So it's speculation just because Teresa Halbach came and took a picture of the car and handed him an auto trader and a bill of sale that he's the one that caused her disappearance. Speculation. No proof. Other people have access to Stephen's trailer. Other people have access to his burn pit. Mr. Sawinski's affidavit does not mention seeing Bobby with the key to the victim's car. In fact, the affidavit establishes that Bobby was pushing the victim's car without power on the night in question, placing doubt on whether he was in possession of the victim's car key. No, it means he doesn't want the lights on and there to be a sound of a running car. The affidavit does not mention that Mr. Sawinski saw Bobby with the defendant's personal electronics. Who saw Stephen with her electronics? There's no evidence that those items were in the car at the only time that it was linked to Bobby by Mr. Sawinski. Neither the key nor the electronics were linked by any witness or any forensic evidence to Bobby. This is infuriating. The victim's key and electronics could have been taken directly from the victim or taken from her car at any time prior to or after the murder by another individual long before the auto was in Bobby's possession. There is no evidence of record taken from the car that links Bobby directly to the actual homicide of Ms. Halbach, nor is there for Stephen. The Sawinski affidavit, taken as true for the purposes of this motion, directly links Bobby to possession of the victim's vehicle. However, possession of the vehicle does not directly link Bobby to the homicide itself. So, Stephen's possession of his trailer does not directly link him to the homicide. Nothing in the affidavit establishes that Bobby was in possession of the evidence that the defendant asserts was used to frame the defendant. No forensic evidence was found in the car that directly linked Bobby to the murder. No evidence of record establishes that Bobby had exclusive possession of the victim's vehicle prior to the night that Mr. Sawinski saw him on the road, or that Bobby had any control over the vehicle prior to that date. But then why didn't he tell his buddies at Manitowoc? Because wouldn't that have helped in prosecuting Stephen if Bobby told Fassbender and what's the other douche's name? I'm blanking on his name. Wiegert. Wouldn't he just tell his buddies, my uncle made me move this car? Right, Chelsea. So they need pictures then. They just said, oh, Stephen had said he would need a video, and they're like, no, that wouldn't change anything, but they need pictures. No evidence of record establishes that Bobby had exclusive possession of the victim's vehicle prior to the night that Mr. Sawinski saw him on the road, or that Bobby had any control over the vehicle prior to that date. None of the physical evidence presented at trial or subsequently links Bobby Dassey to the actual commission of the homicide in this case. We don't know if there's a homicide. While the defendant asserts that the only logical conclusion to be drawn from Bobby's possession of the vehicle that night is that Bobby was the individual who actually murdered Ms. Halbach, the assumption is flawed. There are other reasons that Bobby could have been in possession of the car that night, including that Bobby was trying to help hide evidence to protect the two individuals directly linked by forensic evidence. What forensic evidence is there that links Brendan to the murder and convicted of the crime? What forensic evidence is there to link Brendan? All you have on Brendan is his false, coerced confession. The defendant's conclusory assumptions drawn from the evidence offered in the affidavit do not amount to evidence directly linking Bobby to the homicide itself. As such, the defendant failed to meet the final standard of Denny test to establish Bobby as a valid third-party suspect in this crime. The defendant also alleged that the state committed a Brady violation by failing to turn over the record of the phone call that Mr. Sawinski made to the Manitowoc County Sheriff's Department in 2005. The defendant accurately summed up the requirements for the finding of a Brady violation in paragraph 87 of his brief in chief, quote, to establish a Brady violation, a defendant must demonstrate that 1, the prosecution suppressed evidence. Check. 2, the evidence was favorable to the defense. Check, check. And 3, the defense was material to an issue at trial. Check, check, check. With respect to the second and third prongs of the Brady test, the court has addressed whether the evidence was favorable to the defendant for the purpose that it was offered and whether it was material to an issue at trial. It was concluded that the evidence did not meet either of those criteria. As such, the defendant failed to establish a Brady violation with respect to the Sawinski evidence. With respect to the statement of Kevin Romlo, cited in his brief, the defendant notes in paragraph 118 of his brief in chief that this statement was submitted to the court in its motion to reconsider the October 2017 ruling denying his second post-conviction motion. The defendant asserts, we are now on page 28 of 31, and I got to leave in 1 minute. The defendant asserts that this claim should not be procedurally barred under the ruling in State versus Escalano Naranjo because the court did not specifically address the affidavit in its ruling on the motion. While the court did not specifically address every document or exhibit attached to the motion of the defendant in its October 2017 ruling, the court considered each filing in full. However, to be clear, the court will specifically rule on the Romlo affidavit with respect to the defendant's current motion. A Brady violation occurs when the prosecution withholds evidence that is favorable and material to an issue in the case. A Brady violation does not occur when the prosecution fails to turn over, quote, the type of information that could form the basis for further investigation by the defense, unquote. With respect to the defendant's theory that Bobby Dassey is a credible third-party suspect, the Romlo affidavit falls into the category of that which could form the basis for further investigation by the defense. Putting aside any credibility issues on the part of the affiant, the affidavit, if taken as true for the purposes of this motion, establishes that the victim's RAV4 was away from the Avery property between the time of the murder and the time that it was discovered on Avery property. As discussed previously, there is nothing in any of the exhibits offered by the defendant that establishes that Bobby Dassey had possession of the vehicle any time before the night that Mr. Sawinski states that he saw Mr. Dassey with it. Nothing in the affidavit of Mr. Romlo directly links Bobby to the vehicle at the time that it was observed by him. So again, two different people, two different times, sees Bobby Dassey with the RAV4. They both report it to Manitowoc back at this time. Yet the court is trying to say that's not important. But Teresa Halbach taking a picture of a car and Stephen being the one to meet her and getting an auto trader and a bill of sale means he did it. Sorry. Putting aside, let me see if this is where it was. Putting aside any credibility issues on the part of, I read that sentence. As discussed previously, there is nothing in any of the exhibits offered by the defendant that establishes that Bobby Dassey had possession of the vehicle any time before the night that Mr. Sawinski states that he saw Mr. Dassey with it. Nothing in the affidavit of Mr. Romlo directly links Bobby to the vehicle at the time that it was observed by him. Mr. Sawinski's affidavit only asserts that he saw Bobby pushing the car after Mr. Romlo saw it parked at a different location. There is no exhibit offered that establishes that Bobby had the key to the victim's vehicle. While Mr. Romlo's information may have been an avenue for further investigation, the exhibits submitted do not directly connect Bobby Dassey to the homicide itself, but just with the victim's car, and failed to meet the standard under Denny to establish Bobby as a third-party suspect with respect to this crime. As such, the failure of law enforcement to turn over Mr. Romlo's statement is not a violation of his constitutional rights as defined in the ruling of Brady. On May 26, 2023, the defendant asked that the court consider another affidavit from Tom Baresh. In that affidavit, Mr. Baresh attests that on the night of November 4th, or the early morning of November 5th, he was performing his duties as a tow truck driver when he observed Bobby Dassey driving a RAV4 on County Road Q. Mr. Baresh states that the headlights from his truck illuminated the interior of the RAV4, and he could clearly see Mr. Dassey, so third person saw Bobby with the RAV4, and someone that was not the defendant in the vehicle. The affiant goes on to state that while he was incarcerated for bail jumping in 2006, he reported his story to a Brown County Sheriff's deputy who discounted his report. Remember, he said this in 2006. Nothing in it for him. He reported his story to a Brown County Sheriff's deputy who discounted his report. Mr. Baruch then states that he did not discuss what he saw again until sometime in 2016 or 2017 when he mentioned it to his brother. The defendant reports that he received this affidavit on 10/2023, but unlike the Sawinski affidavit, it does not provide any information on whether the statements made in the affidavit were verified or the investigation was completed. Once again, assuming for the purposes of this motion that the facts in the Baruch affidavit were true, the facts do not directly link Bobby Dassey with the murder of Miss Halbach. The affidavit asserts that two people were in the car when it was seen driving down the road. While Mr. Baruch states that he can conclusively identify Bobby Dassey in the car, he cannot identify the other individual in the car other than to eliminate that person being the defendant. Once again, the affidavit links Bobby Dassey to being in possession of the RAV4 after the homicide took place. There is nothing in the affidavit that establishes that Bobby had possession or conclusive possession of the vehicle prior to that time. Now I'm late. The affiant states that a second individual was in the car at the time that he saw it driving down the road. The affidavit does not establish that Bobby was the individual who was in possession of the key to the car or the car itself prior to that night. The affidavit only, taken as true, establishes that Bobby was in possession of the car on November 4th or 5th. However, even by the affidavit statements, Bobby was not the only person in the car that night. Nothing in the statement links Bobby to the homicide itself. One would have to leap to the conclusion that if he were in possession of the RAV4 that night, he must be the individual who committed the murder. As previously discussed, no direct evidence in this matter links Bobby directly to the murder. Furthermore, in this affidavit, a new unnamed individual could equally be implicated as the murderer in this case under the theory offered by the defendant. The unnamed individual had equal access to the car and the key on that night in question. The individual could have been the individual who, if the defense theory is correct, could have moved the car back and forth from the property, removed the personal electronics from the car, possessed the key, and then planted it in the defendant's home. As such, the affidavit offered also fails to test in Denny to be admissible to prove the existence of a third-party suspect for this crime. In the alternative to his motions under Denny, the defendant asked that the court grant him a new trial in the interest of justice pursuant to Wisconsin statute, blah, blah. Given the above conclusions reached with respect to the evidence offered by the defendant, there are no legal grounds to grant such a request. And now this is all in capital. For the reasons set forth above, the motion of the defendant is denied. And that is the end of it. So I don't have time to now go over more of my thoughts on this. We've already been on here for over 2 hours, and I have to be somewhere in 7 minutes. So possibly tomorrow after work, and I have to work later than I worked today, maybe I will go live again and we can just do more of a discussion. I don't know if it will be here or if it'll be on YouTube or if I do it at all. Don't know. But I'll also be looking into what are the next steps in his case. His case is not over. He does have other courts he can go to. Kathleen Zellner is still on his case. She has said it typically takes her 16 years to overturn a wrongful conviction, and she's only been with this case since January of 2017. So it sucks. These things take a while, but that's what it is. So when I determine if I'm going live tomorrow, I'll try and let you know. I work for a state representative, and so when I'm on the clock, I can't do anything outside of state business. So my moderator is the one that would have to let you guys know if I'm going live, if I'm able to give you an earlier heads up. If not, I'll have to wait until I'm off of work for me to make a post and let you know I'm going live, and maybe where we can just discuss this mess. In the meantime, make sure you check out, so this is Stephen Avery Project. That's public and open to anybody to see. We've got the Stephen Avery Project closed group. Then we've got the closed group called MAM Gossip. I'm always surprised when people don't know what MAM stands for. It's making a murderer. MAM Gossip, that's where people are able to talk about more of the guts of a, and know that at the very beginning of this, in the comments, I posted the link to where you could read that all for yourself. And and it's also posted on Stephen Avery Project. Derek says, how and why did Stephen have her phone number? It's not odd. It's because Teresa had been there several other times taking pictures, and she makes $20 if Stephen just contacts her directly that he's got a vehicle to sell. She wanted Stephen to call her directly, so she'll make $20 instead of $10. But when Stephen made this appointment for Barb's van, he called Auto Trader and set up an appointment. Didn't call her directly. Could have called her directly. Did not. So, all right. I really got to go. Thank you all, everybody. And thank you for everybody who's been supporting Stephen and Brendan all these years. And we just soldier on. We know they're innocent, and, we're going to be here until they're free. Investigation continues. Maybe see you tomorrow.